Good afternoon, everyone, and welcome to this month's second Wednesday afternoon break with Foster Swift. I'm Mike Kassar, a Foster Swift attorney in our firm's employer services and workers' compensation defense practice groups. For those of you who are new, who haven't showed up to one of these sessions before, we host this webinar on the second Wednesday of each month, and I interview other Foster Swift attorneys about important and relevant topics in the law, which there are so many, especially today. And today I'll be interviewing Alex Rusek. Alex is a senior attorney in our Lansing office, and he's a really experienced litigator. He handles all aspects of trials, including trials of civil cases, criminal cases, administrative and regulation cases. He's a cum laude graduate of Michigan State College of Law and received his law degree or his undergraduate degree from Oakland University. Today's interview will focus on a very important topic in the realm of criminal law, one of Alex's specialties. It's Michigan's felony sentencing guidelines. Alex is going to give an overview, but he's also going to go in depth and provide as much helpful information as possible. If you have any questions throughout, you can type them in the chat. I'll be monitoring, and I will relay those questions to Alex. You can also reach out to Alex at the end of this session or afterward, and we'll put his contact information in the chat so you have it handy. All right, Alex, thanks for being here today.
Thank you very much for having me.
Can you first just give us a little bit about your background and your criminal law experience?
Well, thank you for the introduction. A little bit about me, as Mike already said, I'm a senior attorney at Foster Swift, and I'm based out of our Lansing office. While I'm in Lansing, I practice criminal defense across the state, everywhere from Grand Rapids to Detroit, everywhere in between, able to help and have experience in those different courts. I've been an attorney for about 10 years now, and I've had the opportunity to represent clients in all kinds of different criminal situations. So things like operating while intoxicated, which is what Michigan calls our drunk driving offense. Everything from those kind of normal, everyday routine cases to the most complex. I've tried multiple homicide trials and other serious crimes. Right now, I'm also representing a defendant in the Flint water crisis criminal prosecutions, and those have been going on for approximately 6 years now. So it's a pleasure to be here, and I hope that I can share some of my experience in this realm. And I really do enjoy answering questions about a complicated judicial system that most people don't have firsthand experience with. So as we go through, and if anyone has any questions, feel free to throw them in the chat, and always feel free to reach out to me afterwards as well.
Yeah, thanks, Alex. So today, essentially, we're here to talk about the felony sentencing guidelines here in Michigan. But before we talk about that, can you just give us an overview of what a felony crime is, what a misdemeanor crime is, those two different types of crimes we have here in Michigan?
Sure. So in Michigan, we have separate prosecuting authorities. If we think of the federal prosecutors, the assistant U.S. attorneys, they prosecute federal law. We then have county elected prosecutors who prosecute Michigan state law, as well as municipal prosecutors as well that prosecute local ordinances. So we're going to be limiting our discussion today just to prosecutions under Michigan law, the state law. That's the most common kind of prosecutions, and this is kind of the day-to-day in our local courthouses. So a Michigan criminal offense falls into one of two categories. You have misdemeanors, which are lower level offenses, and then felony offenses, which are more serious. Generally, a misdemeanor is going to be punishable by no more than a year in a county jail. And then a felony is punishable by a year and a day or greater in prison. Both of them can also have other consequences, such as fines and costs associated with them, probation, parole, or possibility. But the big difference is whether or not prison is on the table for these kinds of charges. So an example of misdemeanors would be like operating while intoxicated, simple assault, many driving offenses, reckless driving is a misdemeanor. Felonies in Michigan are your serious crimes, your homicide, criminal sexual conduct, weapons offenses, serious assaultive crimes, they all fall into that felony side of things. In Michigan, we also have local ordinances that generally track state misdemeanors, and we have civil infractions as well. In a civil infraction, it's not a criminal offense, but it's pretty close to it. But those are only punishable by a fine of some kind. So if you think of like a careless parking or a double parking, those kinds of situations you would have in a civil infraction, not the criminal offense. So today we're going to be talking a little bit more about those felonies specifically, but we won't be covering the minutia of it. This is only an introduction, but we won't be covering things such as specialty courts, deferral programs, alternative sentencing options. Those topics could take us hours to talk about.
Yeah, that was a really good overview. So I'm trying to think a little bit big picture here. There's a whole bunch of different steps in the criminal justice process. After one is charged with one of these criminal offenses that you just talked about, either a felony or a misdemeanor or a civil infraction, there's a process here. And I think at the end of the process, and you can correct me if I'm wrong, there's the sentencing process. That's what we're going to be talking about today in terms of felonies and how a sentencing can go. But can you just describe that sentencing process in a little bit more detail?
Absolutely. So sentencing is generally the last court appearance for a criminal defendant. That can occur after a trial. It could occur as a result of a plea agreement, but it's generally the last step in the process. So to get there, just briefly, a criminal case in Michigan will start in district court. And eventually that criminal case will go to trial. If it's a misdemeanor, it'll be tried in district court. And if it's a felony, it would be tried in circuit court. For 99.9% of felonies, you're going to have a plea agreement of some kind reached, and you won't have a trial. But in the small percentage of cases, you will have a trial. And if the person's convicted, they'll have a sentencing. So what happens is the court will get a report from the probation department, and then the defendant and their attorneys provide information to the court as well. When we're actually there at sentencing, we have an opportunity to address the court, talk about the case, make our arguments. And one of the big parts of that hearing and getting prepared for it is calculating a defendant's potential sentence under the Michigan guidelines. And what those guidelines are is a series of calculations and a point scoring system, essentially, that are meant to guide a judge in his sentence or her sentence. They are no longer mandatory in Michigan. They're only advisory, but the vast majority of judges will use those guidelines to fashion their sentence.
That's super helpful information. I think you have a PDF or a document, and you can kind of walk us through what these sentencing guidelines look like. That would be really helpful.
Great. And thanks again, Mike. So I'm going to be showing a couple of exhibits here just to give you everyone a little bit of a flavor of what we're talking about. And where these come into play is prior to a judge rendering his sentence, we calculate the guidelines, and of course, those are used at sentencing. To get there, we start off with the Michigan Sentencing Guidelines, which is a series of laws that are changed pretty often. And if anyone has questions about the specific statutes or anything like that, more than happy to talk about them. A lot of minutia there, but the big picture is that we try to fashion a sentence that addresses the need of the individual defendant. So I'll start off. I'm just going to share my screen real quick. And Mike, if you have any trouble seeing this, if you could just let me know.
Yeah, of course. Yeah, I see the document. There it is, sentencing grids. I see that.
Okay, great. So this is starting a little bit at the end. And we'll come back and kind of explain this, but ultimately this is what we're going for. We want to take the defendant's personal history and the facts about their offense, use those to figure out what that sentence should be. So we'll come back and look at some of this big picture, but we're going to first talk about something called prior record variables. That is the defendant's history. And if you'll see on the chart here, we are going to be talking about the PRV level that someone ends up at. And that is scored on the guideline, the grids here. Next, we'll talk about the offense variables. And those are scored down on the left side of this grid. Depending on the scoring, we then come back and we can figure out what the potential minimum sentence can be. So our first task, and this is the probation department, the attorneys, and the judge all kind of working together at this point, is we want to make sure that we have our information accurate. We do that. The probation department prepares a report, and then the attorneys argue about the scoring. So we start with our prior record variables. There's 7 different categories that are scored for any offense. This is, I'm showing you just an example of prior record variable number 1. So if I was looking at this variable, I would go and talk to my client, ask them if they've been convicted of what are known as high severity felonies. I'd go back to the information that I have from the court, verify that it's true. And then depending on what that information is, we can score them on this prior record variable. So for example, if I had a client who had 2 prior high severity felonies from convictions before the current case, then they would score 50 points on this variable.
Alex, just to interrupt you real quick, and this is just my curiosity, does it matter what jurisdiction the conviction was in, whether it was another state, federal, or does it have to be just Michigan convictions?
It is anywhere.
Okay.
And what we would do is we first look to Michigan law and see if we have the same offense in our books. If we don't have something that's directly comparable, then we do our best to take that out of state offense and compare it to something in Michigan so that it can be accounted for. But this is going to take into account any conviction anywhere for them. And so we do that. There's 7 other prior record variables that we go through and score. We ask about the person's criminal history as far as misdemeanors. Juvenile history also comes into play in the scoring of these guidelines. And once we get through on this part, we move into scoring the offense variables. So we know the person's background. Now we're going to look at what they have either been found guilty of doing at trial or what they've admitted to be guilty during a plea. So that part, so after we're done looking at the person's history, we go and we start looking at what are called the offense variables. And I'm showing you just an example of offense variable 3. There's 20 different categories that are scored. And depending on what the person has pled guilty to or found guilty of, then that determines which offense variables are scored. So for, say, offense variable 3, we're looking at whether or not the victim suffered a physical injury during the course of the crime. So if someone was killed and the offense is not a homicide that person's being sentenced on, then you would score 100 points. That's just reflected on the left side there. And then if someone wasn't hurt, maybe they had life-threatening injuries, then you could score at a lower amount. If they just had some medical treatment but not serious at all, you could score even lower. And if they didn't have any injuries, you score at 0. So we work through these 20 variables, and they look at things like physical injuries to a victim, psychological injuries to a victim and their family, whether or not the offense was part of a greater scheme, if there was any kind of gang involvement, multi-offender situations, if the person was on bond or parole or probation at the time. We look at all these different factors, we add them all up, and we get a score for the offense variables. And when we have the prior record variables scored and the offense variables scored, we then can come right back around to where we started. And we have these grids that we call them. We line up. Oh, I'm just going to annotate here a little bit. So we line up what our scoring was on the prior records. So let's say someone maybe had a felony and some misdemeanors. They'll score, say, 20 points. We know that we're in this column now, the C column. And the scoring of the offense variables, it'll take us somewhere on the left-hand side here. So let's say the person had 55 points. We then match those up and we find ourselves down in this 180 cell. That 180 stands for 180 months, and that is the minimum of the guideline range that the person should be sentenced in by the judge. The upper end of that minimum range, we go to the top of this cell right next to it, is 300 months. So an appropriate sentence for a judge to give based on the guidelines would be between 180 to 300 months. Pretty severe sentence right there. The guidelines also take into account whether or not someone is what we call a habitual offender. And you'll see over here, we have like this 375 number, 375 months again, and that would be for habitual first offender. Habitual second would be below them.
Alex, so I don't know if you were going to say anything else, but I do have a question here. As I'm looking at this, I'm wondering the process here. So I would imagine that you're going to have your own copy of your sentencing grid, what you believe that your client might get if they're convicted of a crime, right? And then you take that to the prosecutor, the judge, and the probation officer, and there's some sort of collaboration going on, and you're trying to argue for a lower amount than maybe the prosecutor is going to want, right?
That's almost always the case. So
is that how the process works generally, though? You'll have an idea of what your client might get or what you're going to try to argue for, and then you take that to the other parties, and that's really where the criminal defense attorneys, they really have to show their strength, right?
That's right. That's where the rubber meets the road, both in those negotiations as well as argument in front of the judge. So oftentimes we can come to an agreement that the guidelines are scored correctly. But if there's that disagreement, then we go in front of the judge and both sides argue for their position, and the judge will eventually make a choice. And he or she will say, I'm going to score it this way. Depending on who that decision is against, it is an opportunity for an appeal at that point based on that scoring. Those rarely go through though. The other way that we use the guidelines as a criminal defense attorney is in negotiations. So we have different grids. The one that's on the screen right now, this is a sentencing grid for someone who was convicted of murder in the second degree. We also have sentencing grids. This is for Class A felony offenses. There's more information, more options there. And then I have this grid from the Class E felony offenses. You'll see the numbers change drastically when we go from that murder in the second degree to almost our lowest level offenses. And I say that because your criminal defense attorney who knows what they're doing can negotiate with a prosecutor as to what cell is appropriate for sentencing. And that's one of the tools that we use. So having a really strong command of the sentencing guidelines and the case law surrounding those gives you a significant advantage in negotiating with prosecutors and knowing how these guidelines work. This is a lot of the behind the scenes work that we do as criminal defense attorneys that unfortunately doesn't get seen a lot. but it's a critical step in these kinds of cases and something that has to be looked at and accounted for.
Alex, are there other things that you do as a criminal defense attorney in this process, the sentencing process, to help mitigate a client's sentence? Are there mitigation letters that come into play? What other things can you argue to a judge?
Well, my personal philosophy on criminal defense, and this is from the initial call that I get, is I look at cases in two ways. First, we look at if there's any kind of legal defense to the case. So we're looking at whether or not there was maybe some unlawful action by the police. Maybe the allegations don't match up with the crime and the statute as it's written. Anything that we can consider a legal defense. We start thinking about those from the very first day. On the flip side, though, we also start preparing on the mitigation side. And that starts from day one. And I'll use a drunk driving case as an example. So a drunk driving case, I'll start off looking to see if there's any legal issues with the traffic stop, the arrest of the person, the blood or alcohol, or excuse me, the blood or breath sample that was taken by the police, and we'll challenge those. But at the same time, I'll also be having that client engage in services and with professionals that we have vetted and we've worked with before to, one, if there is some kind of underlying issue that needs to be addressed, then we can put them in contact with the right people to help them out and figure out what's going to be the most beneficial for them, what works for them. So an example of that would be maybe individual counseling services. It may be having them attend an Alcoholics Anonymous meeting, maybe attend continually, having the person meet with our substance abuse assessor and following their recommendations. We get all of that process started from the very get-go. So even if we have a great legal case, we're always preparing for that possibility. And it helps the case, certainly, but also on a personal level, I find that it helps our clients get through a very tough part of their life. And for the vast majority of them, this is the first time that they've ever had interaction with the criminal justice system. And it's a scary and complex system if you don't have someone to help you guide you through it. And I see that as one of my main goals. And this is all to bring back around that when we get to sentencing, we've been preparing for that day from the very beginning of the case. We hope it never comes, but we're prepping from the absolute very beginning. So when we talk about like letters of support, we'll be gathering those through the days and weeks, months as the case moves on, so that we're ready to present those in the best way possible to the judge at sentencing. We also do things like practice sentencing. We go through what's going to happen step by step on the day of sentencing, so that there's no surprises and that we can eliminate the unknown as much as possible. And for me, it's just taking out that part of uncertainty and anxiousness for my clients that I put at the forefront. I want you to be comfortable. I want you to know what's going on. And I want us to be absolutely prepared when we're in front of that judge.
Yeah, that's incredibly helpful. For those in the audience today, I'm just going to ask Alex one more question. If you or your family members or a friend is dealing with a criminal matter, Alex, what should people do in that situation? Is there anything, what steps do you recommend?
The first step is the easiest. That is, don't talk. That's it. So if you or a family member or a friend have a situation where there may be allegations that are being made and police are involved, the first step is not to say anything to the investigators. Their job is to build a case. It's not to find anyone innocent, clear someone's name. They are looking to build a case. Anything that is said can and will be used against you in a court of law. And you have to be very careful, because even telling investigators something innocent, parts of it can be taken and used against you or the person who has these allegations being made against. So first and foremost, we stop what's going on, we control the situation, and then you get in contact with myself or another attorney at Foster Swift. Make sure that we can get into the situation early. We start by contacting the law enforcement agencies on your behalf. We stop all communications with you to make sure that you don't have that stress coming into your life anymore. And essentially, our role at that point is to serve as an intermediary between law enforcement and our client. So at that point, we stop all contact. There's not going to be any kind of interrogation. Police aren't going to be showing up at anyone's doors. At that point, once we have a handle on the situation, there may come a point in time where we do facilitate interviews or proffers with law enforcement, but those are under highly constricted and controlled conditions. So the absolute first thing, if you, family member, loved one, friend, if you have any potential for allegations being made, first step is just stop, don't talk, and then you want to contact an attorney as soon as possible so that we can get involved and control that situation.
Alex, that was really helpful. Thanks for all the good information. I'm going to put Alex's information, I believe, is in the chat already. If you have any other questions for him, you can contact him. His phone number is there. His email address is there as well. This session today is going to be recorded, as we always do. It's going to be sent to you via email and posted on our website too. So there's a lot of different ways you can access this information if you want to see it again. Next month, we're going to be back here on June 14th at a different time. Usually we do noon like we did today. On June 14th, we are going to be here at 9 a.m. I'm going to be talking with Tony Delamonte. He's an attorney in our Southfield office, and he's going to be talking about another really interesting topic. This is an employment law issue. We're going to be talking about the legalities of employers using artificial intelligence during the hiring process. And this is a really timely discussion because we're hearing so much about AI, artificial intelligence in the news, and how it's advancing so quickly. So I'm looking forward to talking to Tony about that. Thanks for tuning in, everyone, and we hope you have a good rest of the day. Take care.
Have a great day, everyone.